Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Yesterday, I have seen in the news that the amended major criminal acts now that have taken in law shape. It has become a statute. The Indian Penal Code, which we are going to hereafter call as Bharathiya Nyaya Samhitha. So there are some changes. Previously, we used to have 511 sections. Now they have been reduced to 300 or so. And the important change which I wanted to tell you is regarding section 106 of the new code. Normally, it is comparable to section 304A IPC of the previous Indian Penal Code. What does section 304A say? Section 304A provides that if any person does any act in a rash or negligent manner resulting in the death of any person, this man is liable for punishment up to 2 years or with fine or with both. That is the previous section. That means if anybody buys a rash or negligent act, normally we apply the same in the case of accidents. If any person drives his vehicle in a rash or negligent manner and causes death of a person, then he is liable for punishment for 2 years. Of course, there are so many comments. 2 years is very, very less because it is nothing short of murder. If there is intention, it is nothing short of murder. Since there is no intention, previously they have decided to make it punishable up to 2 years. Now it has been enhanced to 5 years. At the same time, now 304A, you have to read it as section 106. Section 106 deals with three things with amendments I am telling you. Number one, due to rash or negligent act, if any death takes place, 5 years or with fine or with both. Then, if anybody, this is relating to hit and run cases, if anybody hits any person and goes away without reporting the matter, as envisaged in the MV Act, then he is punishable. His punishment may extend to 10 years. Another very good phenomenon. Proposal. And third one, this is, of course, I can't say it's happy news, but it is a solace to the medical officers. Because in the law of torts, I have been telling you regarding the medical negligence cases, professional negligence cases. In that medical negligence cases, we have discussed so many cases like Aparna Datta versus Apollo Hospital, Dr. Tokuga versus Apollo Hospital. And very famous case, the beginning cases, we have discussed that Indian Medical Association versus VP Shanta and others, 1995 case. But in the case of Jacob Matthew versus State of Punjab, 1995, I have told you that do not fix up the doctors unnecessarily for the medical negligence. That's why, age-old back, Lord Macaulay's time, Section 87 and 88 of the IPC, they gave exceptions. They are the general exceptions. The doctor doesn't want to commit the murder. By mistake, it may happen. Then what are you going to do? Are you going to punish him? Of course, if there is medical negligence and if you are able to prove it by means of, for ordinary people, if you are able to prove it by means of res ipsa loquitur, definitely you can file a case. But you should not file cases against the doctors without knowing whether it's a medical negligence or not. For that purpose only, in the case of Jacob Matthew, Honorable Supreme Court of India stated that the police officers, they have to consult a senior civil surgeon or team of doctors to check up whether the negligence has taken place or not. And even though the people file a case, private case before the court should not take it immediately. They have to refer it to the police have to refer the matter to the medical officers, team of doctors, then only you can take action. Of course, it is a palpably evident case, or I told you just now, I told you the rest ipsa loquitur, definitely you can file a case. Now, according to section 106 of the Bharathiya Nyaya Samhitha, if any death is caused due to the medical negligence or negligence of the medical officer, the punishment may be up to 2 years. Friends, I told you, if any driver drives the vehicle, causes the accident and kills a person, 5 years. If anybody causes accident, goes away without reporting the matter, hit and run case, 10 years. But as far as the doctors are concerned, it is 2 years. Simple word I will tell you. If you keep on going medical negligence cases, then a shivering doctor cannot conduct the operation with the so-called trembling feet or trembling fingers. You should give them the courage. Vaijo Narayano Hari. Doctor is a demigod. He will give life. No others can give life to you. So give respect. That's why, with that intention only, yesterday, 106 clause 2, that amendment was brought by our Honorable Home Minister, Sri Amit Shah ji. So this is regarding 106, very good amendment or very good restructure. I can't say amendment. Restructuring Bharathiya Nyaya Samhitha. From tomorrow onwards, you have to call it as that name, in that name only. Of course, as elders, we may not be able to recite or we not remember the sections of law because we are habituated for the past 40 years being in the police department from 1976. So we have been conversant with up to the 511s, 1 to 511 sections. It may be difficult for us. Anyway, let us see what will happen. But anyway, with this video, you have to understand that the cause of the doctors has been taken into consideration by the government of India, and with which only the punishment of 2 years was framed for the medical negligence cases. Okay, please read of course, you have to read the provisions of law, and definitely it will enrich your legal knowledge. With this, I am concluding. Thank you very much.